What we want to do for this afternoon is that Professor Woods and I are going to uh, provide some preliminaries for a discussion. And so that the discussion is going to take place around our table here with what we call our conference owl. It's a device that I really enjoy because it can pick up the sound from the person that's talking, and it's going to be projected up on the screen, and so it gives us a good opportunity to provide a nice recording of it, as well as to allow the participants to talk to each other as opposed to being spread out. But what I wanted to talk about first is what happened within the mining and mineral exploration in the world before we had any laws. And so I've broken that down into our hegemons and free miners, the Carolingian treaties that would have been during the time of the early Holy Roman Empire, some of the laws of New Spain, and the mining district regulations of the gold rush. And I'll also cover some of the activities in early Arizona. One of the things that I kind of like in the theme is T.A. Ricard wrote a book on man and metals in the 1930s, and he came up with the phrase that civilization follows the flag, but the flag follows the pick. In other words, the mineral exploration activities went out there first, and that brought in the semblance of a civilization, although when you look at some of them, you weren't too sure what that civilization was actually made up of. When you look at the terminology applied by historians throughout history, they come up with this hegemon that several years ago I didn't know what that was, but in essence, this is the big man, whether or not it's the chief, king, prince, etc., but the person or entity whose authority is unquestioned. And then finally, we're looking at some of the self-governing practices that the miners have used. The hegemon themselves were principally the mines of Egypt and Assyria, and these would have been exploits of the individual kings going into mineralized areas. And they, of course, were interested in minerals primarily for use in armament, and to the extent in using metals for fiscal supply. So gold and silver, in addition to the copper and tin to create bronze. And actually the idea of the creation of bronze in the early in the late Neolithic periods was really the impetus to a trading network, because the bronze is made up of copper and tin, and so you needed to create a trading network in order to find the tin to mix with copper to come up with bronze, which was a much better tool for implements of war. The mines of Rio Tinto are also a very important element here, because we've seen some of the first elements of a system of providing for leases to exploit those copper mines. Some of the first laws that we can see were made up of plates that were found in Portugal that described, how how the Roman Empire worked that. The early miners were, like I said, either the kingdom itself that was exploiting the mines for their military and fiscal purposes, and so they simply wanted to get the materials out as quickly as possible. The idea of any sort of environmental concerns were obviously one of the least of their worries, except from the standpoint they wanted to make sure that the slaves that they have working the mines were not wasted. And so the first environmental concerns we have is primarily looking at trying to preserve the slave populations. The Treaty of Trent is a good example of how mining expertise devolved to certain tribal entities. The term Bergbaufreiheit is German, that in essence is talking about the free miners. In other words, these were not serfs. They had the ability to travel throughout. They were not, or throughout Europe. They were not tied to the ground, and they were the ones that knew how to mine and produce minerals, or primarily silver, from the various sources to provide money for the individual bishoprics that were running the mints. This situation probably came about because of the fact that the Pope at the time was quite weak and really couldn't control things within the whole empire, or such as it was. The historians at the time talk about the Holy Roman Empire by saying that it was neither holy nor Roman, nor was it an empire, but it was a highly fragmented area that was run by these various bishops. And what the bishops had to do then is, in order to maintain their fiscal security, was to create situations where they could attract these mining tribes to come in and mine their resources. The deals that they usually made, in essence, was to come in, produce the minerals, and to sell them to the mint. And so the miners were able to pretty much make up their own rules as to how they did this. We do have a number of treaties. One of them is one of Trent, which is in northern Italy, right on the border between Italy and France, in 1185. And that describes how the miners, or how these free miners could come in, stake out portions of their claims along the veins, and they would then have those claims themselves. You had to, the areas immediately adjacent to that first discovery were allocated to various important people within the bishopric, but I think it was the miners themselves that were able to mine the materials, sell them to the mint, and have most of the proceeds themselves. We found pretty much the same thing in England. There were a number of inquisitions, and on the terminology that we're talking about here is an examination of what is going on. So the king would order an inquisition. They would send the officials out to take testimony as to what the miners were doing. The best one we have is the Inquisition that took place in 1290, and we know pretty much what was happening there. And it was really the memorialization of what took place at that Inquisition is what we know about the laws of early England. In essence, what we had here, let's see if I have this Inquisition was referred to as an examination as to what the ancient practices of the miners were. And so obviously this has been going on for some time. And it was a way of recognizing the right of miners to come upon this wastrel lands, in other words, in unoccupied lands, and to claim specific parcels with showing a value of minerals. One of the interesting things I find here too, it was the first real evidence of what we call extralateral rights in this country. So if the miner was able to identify the existence of mineralization at the surface, the terminology was that particular vein was liberated, and the miner was able to mine mineralization within that liberty. The only real obligation of the miner at that point was to contribute 1/16 of production to the owner of the surface, or to the individual lord. And so it was called the 16th dish of that material went to the lord of the manor. Now, when Columbus was about to come over to the New World, he made a deal with Queen Isabel, and the contract shows that he really didn't give much thought to the potential mineral wealth, and he was mainly interested in setting up his family as governors of his discoveries. But he did get to keep 1/10, or the royalty obligation was 1/10, but the prerogatives at the time simply proclaimed that all minerals belonged to the crown and could be worked only with a special license. This was changed really with the discovery of substantial silver deposits in Taxco and Jalisco. There were no rules in the New World at the time. The idea was that most of the mineral values had to be returned to the crown, but Viceroy Antonio Mendoza was the first one to come up with a code that he adopted with the assistance of the miners at the time. And I think that from my standpoint, the interesting thing about it is that it really mirrors the practices that wound up being applied in the California Gold Rush, that in turn became part of the mining law of 1872. But the way that worked is the discoverer could claim ownership of a single vein that was measured 80 by 40 varas. A vara is almost a yard. This person had 15 days to register the claim, or the rights were lost. Had to sink a shaft and define the boundaries during the first 3 months. And if the mine wasn't worked within a year, it could be denounced. In other words, it could be legally jumped by third parties. In 1574, a code was passed by the viceroy in Peru that included both Peru, Argentina, and Chile, that used essentially the laws that were being applied in Saxony. But the only real difference there was that established an alcalde mayor de Minas that was charged with the supervision of the mine. There was a structure governing what the miners were about. But what happened in California is what we look at mostly to see what sort of individual laws or what the miners individually came up with. You may remember that when gold was discovered in California, the war with Mexico was just barely ended. I think it was about 2 weeks after signature of the Treaty of Guadalupe Hidalgo, and the military authorities in California, the Army of the West, the colonel there really didn't know what to do. And so the idea was that he recognized the fact that he didn't have the military might to be able to control the miners at the time. And so he just let them go. And I think that what really broke the dam on it was that he issued a proclamation that the miners could do what they wanted, and that the laws of Mexico and Spain would not apply. So what happened was that the miners flooded in. They applied the laws of Mexico and Chile as they understood them, as well as what are called the rules of the Iowa claim clubs. What was going on there is it was during an era of homesteading, and the laws related to homesteading, that before the survey has been extended on the land, you had no right to make a homestead claim. And so these homesteaders were going out there and squatting on the land and waiting for the survey to arrive. But in order to protect themselves against attempts to take over their homesteads by force or other technical means, they formed these clubs of self-protection. And so that same idea was transferred to California by the individual miners. And what they would do would be to make regulations within the individual mining districts. It started out with once a discovery was made and the miners were starting to come in, they would have a meeting of all the miners in the area, and they would elect initially a president and a recorder, and prepared bylaws to define the limits of the mining district. And this was sort of an example of the news that went out after the announcement that the gold fields were open. This was an ad that was, I think, about 1849. Now, within these regulations that the miners are writing themselves, the first thing they did was to place restrictions on ownership. They didn't want large groups to come in and stake lots of individual claims. And so in essence, the rule was that you could have a right to your individual claim, but any additional claims that you had to obtain them by purchase. So it was really looking at the development on an individual basis. They fixed the size of the claims, and it usually varied substantially. Most of these were placer deposits. In other words, these are free gold found within the alluvium of the rivers that were flowing down from the higher countries in California. And those claims were, sometimes several hundred feet. In particularly rich areas, it may have only been the length of a shovel. The miners had 15 days to record their claim. They had to keep working the claim, and if they abandoned that claim for more than a couple days, they would lose it simply, or it would open it to the possibility someone else could jump that claim, and sometimes even required the leaving of equipment or the shovels on the site to show that the intention was to continue the working. The disputes were settled by the miners themselves within the districts, and the president acted as the judge. And here's an image that I found in Harper's Weekly, and you can see our judge. Well, I don't have the pointer here. Oh, this is the pointer down here, isn't it?
I think my pointer's still up here.
Yeah. Here's our judge. So I think that between serving up drinks, they could hear the case, obviously being argued by one of the folks there. But the interesting thing to me is that the jury was made up of every single miner within the district. And so I've seen in some of the reports of those decisions that you might have a decision that are 35-17 in favor of one party. So it was really sort of a committee of the whole operation. One of the more important things I find here is this little sign on the wall. Lawyers must not be long-winded. And as a matter of fact, there were a number of districts that actually prohibited lawyers from practicing law. I suppose maybe I shouldn't go on with the comments there, but I think that it does show the importance that the miners have traditionally felt towards the interpretations of what they considered their own laws.
Hey, John.
Yeah.
John.
I'm sorry?
I just had a little vignette here. I just read recently that one possible origin of the term kangaroo court is from exactly that kind of thing, where a claim had been jumped like a kangaroo.
Okay.
And that these courts came about and were called kangaroo courts because of that, in order to settle the dispute.
To decide who was the kangaroo, huh?
Yeah.
Well, that's interesting.
There are some other suggestions too, but that's
Yeah,
one. In the gold fields.
Yeah, because the gold fields in Australia, I think that the Australian gold rush was about 1851 to start with, and so it's shortly after the California gold rush, and so I think that there may very well be some possible connections there. This next slide is probably a good example of the social problems that they had. A lot of the regulations that they had at the time prohibited certain groups that they considered inappropriate, and that the Chinese were the ones that were primary ones that they wanted to keep out. We had a similar situation in Arizona, where there were prohibitions up particularly in the Walker mining district, against Mexicans owning claims. And as you look at the history of the Walker mining district, after a while, they eliminated that, mainly because they couldn't decide who was not a Mexican. The environmental problems is certainly one of the biggest issues you had at the time, and this is an image of the hydraulic mining that was taking place in the upper reaches of the California River system. These high pressure water systems, they would run the water down into these, trying to think, can't remember the name of these particular monitors. That's what they were called. And so the water was forced out by gravity, and these would wash down the mountains. You can still see these. There's some of the old California mining camps. Some of the old monitors are still around, and you can see still see the results of that hydraulic mining. But the basic theme that you find throughout these older mining promulgations is that the right of property in mines is made to depend upon initially this discovery, to go out and find the mineralization in some form of reasonable development. And that the discovery is the source of title, and the development or working is what you need to continue that title. And this was a statement made by H.W. Halleck in his introduction to some of the fundamental principles of the law of mines that he wrote in 1860. Halleck was a lawyer who was the aide de camp to the general that was the commander of the Army of the West. So, what of space exploration? And that's something that we can talk about during the rest of the afternoon here. Just ask the question, can we apply right of possession based on some form of discovery, and what is discovery going to be? What sort of tenure will be required for financiers? And I think that we have a good point here in the application of the law in California. Most of these deposits that were mined by the mining districts were really very superficial deposits. The individual could go out there and make a claim and wash out the gold from the alluvial gravels. But at the time when lode mining started, in other words, when you started having to bring in equipment and to move large quantities of rock, that's when you needed to apply a lot more financing. And it was really the British financiers that required some form of tenure, and that's probably the principal reason for the establishment of the mining laws first enacted in 1866. And finally, I asked the question, who's going to write these rules? Is it going to be a hegemon, some sort of international body, or space prospectors? So thank you very much, and we'll now turn over to Professor Woods